Hello everyone, this is Jonathan Shao, immigration attorney. I want to talk to you about something called exceptional circumstances filings today, which can be very useful for people who are considering filing a family petition and who are currently living abroad. But in order to best explain this, I think it's better to start with a hypothetical scenario that involves a very difficult situation. U.S. citizen Bob has been working for an international conglomerate in China for several years. During this time, during all these years that he's been working in China, he married a Chinese woman, someone who has no status or history to speak of with the United States. One day, Bob received a notice from his employer that he's needed back in the U.S. next month for an important project, and in fact, he is going to be expected to stay in the U.S. for the foreseeable future. If you're at all familiar with the American immigration system, you might already see the problem. Bob's wife will clearly have to accompany him. What's the point of being a family if you can't live together? But in order to help her obtain permanent residency, Bob and his wife will have to go through the usual channels that might take a year and a half or more. This is obviously not feasible. Bob's wife may visit the United States while the process is ongoing, but she likely will not be able to avoid questionings from customs officers with each visit. And in the worst case scenario, she might just be denied entry outright. They will have to maintain two households because Bob will have to live in the United States and Bob's wife will have to live in China. And the situation is even worse if they have children. Where will the children live? So this is where exceptional circumstances filings can come in. With this filing, eligible petitioners, Bob in this case, can file an I-130 form directly with the U.S. Consulate, the Consulate in Guangzhou in this case, and doing so can avoid lengthy processing at USCIS. Exceptional circumstances filings is not perfect. It's highly situational, it has a strict requirements. It is up to the discretion of each U.S. consulate to process, so not all U.S. consulates are willing to do it. Each consulate may have different procedures that are not at all transparent. However, if Bob, his wife, and their lawyer are willing to do some extra work, they can potentially reduce the processing time down from 1.5 years to 2 months. Let's find out how. First, by covering the general requirements of the process. Like its name suggests, exceptional circumstances filings are reserved for circumstances that are exceptional. Bob's situation qualifies. He is transferred by his employer back into the U.S. on short notice. Similarly, a U.S. military member being transferred to anywhere else in the world on short notice may also file so that his family may live in the U.S. I imagine if a military member who's being transferred to a very dangerous place of the world, they would want to send their family back into the United States instead of going with him. Other exceptional circumstances may include medical emergencies or threat to the safety of either the petitioner or the beneficiary. Adoption, where the petitioner has imminent need to return to the United States. So imagine Bob travels to China to adopt a child, and next month, naturally, he would want to return to the United States and bring his newly adopted child back with him. In the last example, if the beneficiary is close to aging out of being eligible for family petition. Here's a little side note on aging out in case you're not familiar with the concept. In family petition, a U.S. citizen or permanent resident can usually apply for their children, but the condition is that the children needs to be under 21 years old and unmarried. Not to say that if the child is over 21 or married is necessarily the end of the case, but they might be transferred to a different category of immigrants that can incur lengthy visa wait times. Because immigration petitions, family petitions, tend to take a pretty long time, you can imagine a scenario where on the date the petition is submitted, the child is almost 21 but not quite, 20-year-old, and the petition takes a long time to process, and the relevant CISPA, Child Status Protection Act rules don't really protect the child from aging out. Then I can imagine a situation where the petitioner will go, all right, well, let's just try for exceptional circumstances filing and see if we can cut down the processing time for our child. CISPA is an entire set of rules that warrants its own video. It's not within the purview of this video, but you can look forward to it on our channel in one of those future releases. So let's get back on track. Those examples of exceptional circumstances I just mentioned were specifically mentioned in what's called the Foreign Affairs Manual. It's a set of documents that consulates refer to determine whether they can and how they should process exceptional circumstances filings. But in addition to those specific examples I just listed, there's also what we lawyers call a catch-all provision on the Foreign Affairs Manual, FAM for short. And what a catch-all is basically a broad provision that says that a consulate can process exceptional circumstances filings, even if it is not in one of the examples that was listed, so long as the consulate determines that the circumstances are exceptional, right? This provides a little bit of flexibility to consulates that allows them to determine on a case-by-case basis whether they want to take on an exceptional circumstances filings case. So our question now is, what situations might qualify? What situations that weren't listed before could also qualify for exceptional circumstances filings? Well, here's some thoughts. Again, it's a case-by-case basis. It depends on the consulate, but I think these examples might have a strong chance. Let's say that Bob's mother is diagnosed with a terminal illness. She's living in the United States, and Bob needs to return to the US from China in order to take care of his mother and really spend the final moments of her life with her. He would want to bring his wife along with him back into the United States, and if he supplies the appropriate documents to demonstrate this exceptional circumstances, he probably has a good chance of getting that filing process by the consulate in Guangzhou. Another example, instead of falling ill, unfortunately, Bob's mother passes away, leaving behind her a sizable estate, just a whole lot of things to manage. Bob can't be expected to just go back to the US for a couple of months to settle all the affairs, so he thought that for the moment he might as well return to the United States and really take care of this for the foreseeable future. This might also qualify. He might be able to supply documents demonstrating the size of the estate and kind of draft a letter explaining what he needs to do and the timeline that it's going to take. That might qualify for exceptional circumstances filing. And the final example I can think of is if Bob is managing a business that has international presence both in the US and China. And he's in China because he wants to work more hands-on with the distribution of his products in China. However, his US parent company suddenly is undergoing a crisis. It's not doing so well. During this moment, Bob might decide to move back to the United States to directly manage the crisis, maybe make some staffing changes, make some important business deals to speak with his business partners and the vendors in the United States. Then he doesn't know how long he's going to stay in the US to manage this crisis, so he might be able to file an exceptional circumstances filing for his wife. In addition to all of those hypotheticals I just mentioned, other situations might qualify for exceptional circumstances filings. The consulate's discretion is key here, because the consulate has broad authority to decide what is an exceptional circumstance. It may be advantageous to attempt direct filing at the consulate if the circumstances seem at all eligible. Try this first, is what your attorney might decide when you're working with them. But in addition to all of those eligibility examples and the catch-all provisions, the exceptional circumstances filings have a couple of other requirements. The first is that the petitioner could not have submitted an I-130 form with USCIS first. And this rule probably stems from the fact that USCIS should have the first dib on family petition cases. The jurisdiction really falls with USCIS, and USCIS is only delegating part of that responsibility to the Department of State and its consulates for exceptional circumstances. So if an I-130 is already pending with USCIS, the consulates would tend to respect USCIS's jurisdiction and not accept exceptional circumstances filings. Be very, very careful then. If someone is considering at all to do exceptional circumstances filing, they will have to decide whether to try things out with the consulate first to see if it succeeds, or to just not attempt it and submit the I-130 with USCIS so they can get a head start on the lengthy processing time. It's a tough decision that they'll probably talk with their attorney about. Additionally, the exceptional circumstances filings I-130 needs to be clearly approvable. If we submit something to USCIS and they think that we haven't submitted enough documents to demonstrate the relationship between Bob and his wife, USCIS by practice would issue what's called a RFE, a request for evidence first. They will let us know what documents they find deficient and give us another chance to submit additional documents to make this case approvable. If in a similar situation, the I-130 is being reviewed by the consulate instead, the consulate wouldn't even bother with issuing anything like an RFE. The petition needs to be clearly approvable, meaning that the consulate officer must see the documents and make a decision on the spot that this is actually an approvable case, which helps with making the processing time so short. If the officer has any question at all about the approvability of the case, maybe the couple has only been married for a couple of months and they barely have any sort of a confluence document to speak of. Their bank accounts are still separate, they're not on each other's insurances, they don't even have share any sort of a title or names on their lease in the place they live, then there's probably a pretty strong chance that the consulate officer would just go, you know what, let's hand this problem to USCIS. I'm sorry we can't do exceptional circumstances filing, but this is not clearly approvable. And then there's the physical presence requirement. Both the petitioner and the beneficiary must be physically present in the consulate's district during at least part of the process. The petitioner, Bob, must personally attend the I-130 interview and bring all the I-130 documents and forms and other supporting stuff with him. While the FAM's language requires the beneficiary, Bob's wife, to stay in the consulate's district until the very end of the process, meaning she finally gets the passport with the visa stamped, my personal experience is actually a little bit different. It turns out that Bob's wife might be able to travel internationally, for example, to the United States during the process, so long as she's able to attend the medical exam and the interview. In most situations, I would recommend my clients to be very conservative with this. If they don't need to do international travel, it's best to just stay in China or wherever they're currently living until they get that passport with visa stamp firmly in hand. It's also worth being mindful of the spirit of exceptional circumstances filings here. The idea is that both petitioner and beneficiary are based in the foreign country, so Bob and his wife should be living in China to even attempt exceptional circumstances filings. This is not a process that's meant to be abused by petitioners who are based in the United States. In fact, the FAM strictly forbids this. Now that we've gone through the basic requirements, let's talk about the process. Exceptional circumstances filings start with getting in contact with the consulate staff responsible. This is a surprisingly difficult task because consulate operations are opaque and they vary from post to post. So exceptional circumstances filings are not exactly common. Sure, you can try to go to the State Department's website and each individual consulate's or embassy's websites, which provide a bevy of contact information. But I gotta tell you, those aren't necessarily helpful because they might connect you to somebody who are just trying to do their job. They get a lot of calls from attorneys and applicants and potential applicants every day, and they're really just trying to get through the day. And if you ask them a question about exceptional circumstances filings, which many of them have not heard of, they might just rebuff you and send you back to the website. So you'll be sent around in a loop, just getting your ball kicked from one sector of the consulate to another. It's very frustrating. Eventually, if you work with an immigration attorney and your attorney might finally nail down the right phone number or email address, after speaking with numerous colleagues in the American Immigration Lawyer Association and reaching out to various parts of the consulate. It's a lot of busy work here. With the right contact information in hand, the attorney can then make an informal request, just hoping the consulate can process the filing. And if thankfully the consulate can process, it will want an explanation of the circumstances to assess whether a direct filing is justified with the consulate. This explanation should be detailed and concise. Petitioners should prepare documents evidencing the circumstances in advance in case the consulate requests for them. For example, if Bob needs to move to the United States because of the transfer by his employer, he should prepare ahead of time a transfer notice or some kind of a transfer new employment agreement with the employer that's signed by both parties, evidencing that he really is going to move to the United States. This is not something that's just up in the air. Maybe he can say yes or no. He's being moved or he's going to lose his job, right? And if the consulate determines that the direct filing is appropriate, it will schedule an interview with the petitioner, where the petitioner Bob will submit the form I-130 and all of the supporting documents. He'll bring all those documents with him. And Bob will speak directly about his relationship with his wife and the exceptional circumstances. He should be notified of the result of the I-130 by the end of that interview. Okay, sometimes the officer will tell them, yeah, I think this is an approvable case, but let me talk to my supervisor first. But in any case, you can expect, or at least Bob, someone in Bob's position, can expect to hear a result at the end of the interview. Next, once the consulate determines the I-130 petition is approved, it will direct the beneficiary, Bob's wife, to submit a DS-260 visa application form. Just like all of the other consulate processing cases, this is going to be done through the State Department's CEAC website, CEAC. Bob's wife might be asked to visit the consulate's online appointment system and select a visa pickup method in case the application is approved, hopefully. And depending on the consulate's particular practice, Bob's wife might also be asked to perform a few other tasks, such as maybe mailing in her passport or some photos or some other documents to the consulate ahead of the interview. It really depends on the consulate's practice. Then Bob's wife will be scheduled for a health exam and interview at the consulate. Similar to Bob, Bob's wife will be asked to bring a specific list of documents to the interview, including some of the documents that Bob already brought. In any case, once the health exam and the interview are complete, Bob's wife will similarly be notified at the end of the interview of whether the case is going to be approved. If it's approved, then she can expect to get her passport with a visa stamp back in the next few weeks, a couple of weeks, hopefully 2 to 3 business days, but depends on how efficient the consulate is. I should stress that process of these exceptional circumstances filings is not standardized. Petitioners, beneficiaries, and their attorney may need to perform the steps above in different timeline and different order. Methods of submitting documents can differ. Time taken for interviews can differ. It's important to remain flexible and just think about all those consular variables as trade-offs for a shorter processing time. A couple notes of caution. This process is for U.S. citizen petitioners only. Legal permanent residents can't really do this. So, I guess if someone is a permanent resident who's eligible to naturalize but doesn't do it for whatever reason, this might be an incentive for them to become a citizen first in order to go through exceptional circumstances filings. Inadmissibility issue for the beneficiary, let's say hypothetically Bob's wife, still applies. Just because this is a faster process doesn't mean all of a sudden we don't think about inadmissibility anymore. So, if there's any history of overstaying in the United States, of misrepresenting material facts to immigration authorities, or, God forbid, criminal issues, then these issues will all need to be addressed as with any other normal immigration visa case. In fact, if these are the issues, then I think the clients will really need to talk to their attorneys about whether it's worth trying exceptional circumstances filings at all. Maybe it is worthwhile to first resolve those issues and then decide how we want to bring in the foreign beneficiaries into the United States. From experience, many family petition case clients, they tend to take time to gather the required documents. And that's really because, for example, I'm terrible with gathering my tax documents for every tax filing season because I have a job and I have other obligations to meet first. It's common, I understand. Part of my job as an attorney is really to get in touch with my clients who are kind of taking their time to gather documents to make sure that things can be filed on time. But with exceptional circumstances filings, we don't exactly have that luxury here. Assuming the consulate is willing to move forward with this, everything must be prepared in a very short timeline. That means additional work to make sure the filings are ready. Both the petitioner, their spouse, or really their children, if they're able to help, and the attorney will really need to do a lot of work in a short time to make sure that we can make this successful. And that's all the details I can share today. I hope this is informative for you guys. I had recently the pleasure of concluding an exceptional circumstances filing for a client couple from China, which is why I used Bob and his wife as an example, although the circumstances aren't exactly similar. This was a laborious and time-consuming case involving a lot of correspondence with the consulate in Guangzhou, but it was very rewarding. My clients are happy because what would have been an 18-month case was reduced down to about 4 months from consultation to visa issuance. I'm happy because I don't have to worry about their case for that same amount of time. I can just start and then end in 4 months, and then I can close the case, and it's great. Everybody's happy. If you find yourself in a situation that might warrant an exceptional circumstances filings, please reach out. I am always happy to help, very happy to do these kind of cases when they're successful. But even if exceptional circumstances filing isn't possible, I'm very happy to work with you to see what option works for you. We are Shao PLLC, or Shao Immigration Law. We are an immigration law firm based in Washington, D.C., but we serve people nationwide. We emphasize honesty and thoroughness to give our clients the best possible service. If you need immigration help or would like to suggest other topics to cover in our videos, contact us. I'll see you next time.